हेलो एवरीवन, वेलकम टू निष्ठा IAS प्रीलिम्स एक्सप्रेस। ये एक्सप्रेस है, इधर तेज़ भागना है। बिगनर्स डोंट से दैट सर को जल्दी पड़ी है, तेज़ भाग रहे हैं, एट्सेट्रा। विल बिगिन पॉलिटी. सो वी हैव सम 10 टॉपिक्स which we have selected. In those, so we will discuss one by one. First, say why it is important for PYQs to be analyzed, because questions repeat. How they repeat? So here there is a question related to the state government and the minor minerals. So here the minor minerals are exclusively under the jurisdiction of the state governments and major minerals under the central government. So here in 2019 we had the same question, that is sand is a minor mineral and state government have the power to grant lease or anything. So by analyzing 2019 question we can answer this question as well, which was asked in 2025. Also here is one more question related to the prisons and prison rules. So here we have state governments have their own prison rules and parole rules. So again here we have that the prisons are looked after by the state government. Yes, law and order is the state subject, and obviously so state government will look after the police, prisons, etc. So by analyzing that we will get the hints, and these hints are more than enough for you to clear prelims, and we don't want that we analyze the whole question and by heart every facts. So make sure that the keywords you pick it up. Now, coming to the philosophical questions, here are some of the philosophies of constitution which UPSC asks. Here there was a PYQ. In essence, what does the due process of law means? Friends, we know that there are two types, that is procedure established by law and due process of law. Procedure established by law means the procedure through which the law is established should be correct. And due process of law means the law itself should be correct. That means we are going for the fair laws. And which philosophy speaks about that the law should be fair enough? That is your principle of natural justice. Yes, so here the principles of natural justice we have, that is first one, no one should be the judge of his own cause, and second, hear the other side or right to be heard, and third, the authorities must give reasons for their decisions and avoid arbitrariness. That means our law should not be arbitrary, our laws should be fair enough. So this third principle of natural justice shows that due process of law means, so that is the law should be fair. That is the procedure established by law is not correct, and due process of law means here it is the principle of natural justice. That is the correct answer. Now, say moving to the other philosophies, we have constitutional morality. What is constitutional morality? It is nothing but the moral principles preached by the constitution. Yes, constitution preaches us brotherhood, it preaches us secularism, it preaches us respect to each other, or cherishing the noble ideals of freedom struggle. All these are the morality preached by constitution. Then constitutionalism. Friends, constitutionalism has been asked by UPSC 2 to 3 times. Here constitutionalism means limited government. Limited government means government cannot act as per its free will. It is bound by the constitutional limits. So what constitution says, only those things they can do, and wherever constitution limits the powers of the government, government should restrict their powers. That is the meaning of constitutionalism. Constitutionalism means it is limited government, not the absolute government. If there is no constitutionalism, government becomes despotic. Then welfare state. So we have to work for the welfare of the people, or the government should work for the welfare of the public. That is the basic definition of welfare state. Then rule of law. Rule of law simply means that so the law should be applicable equally for all, or that means it should not be rule of men or women, it should be rule of law. So it is not that show me the man, I will show you the rule. It is that the same rule applicable for every man and woman in this state. So such definition, if you know it very clearly, it will be very much helpful for your examination. Then here is one more question on the welfare state. So the ideas of welfare state in the Indian Constitution is enshrined in directive principles of state policy. We know that, so there we have free legal aid, or might be the state should provide the allowances for the disabled, Divyangchans, all those things. That is the welfare state is depicted in the DPSPs. Then moving further, evolution of constitution. Friends, we will understand and we will try to learn so how our constitution has evolved. Don't by heart the things. The Regulation Act 1773, so that recognizes the political and administrative functions of the company. That means like now from England, the regulation of the company proceedings were going on, and there was a check and balance. Whatever company does in the Indian mainland, so that was being checked and regulated by the British in UK. So that is why the name Regulation Act. Then moving further with the Regulation Act, Pitt's India Act. So here there was an establishment of Board of Control. Friends, this Board of Control was present in UK, and the counterpart of that, Court of Directors, was present in India. Whatever Court of Directors does in India, that is with respect to East India Company, that was being regulated, or it was being controlled by the Board of Control in UK. Yes, likewise. Then, moving further, in the Chartered Act 1833, the Governor General of Bengal became Governor General of India. So, William Bentinck becomes the Governor General of India. And remember William Bentinck with the abolition of Sati system, etc. And then we have the Chartered Act 1853. Friends, here we have open competitive exam for civil service aspirants. So for our community, so this will become important. Then separate legislative and executive functions of Governor General. That means Governor now has Executive Council as well as the Legislative Council. And in that Legislative Council, there were 6 members initially, and the Act also provided local representation for the Legislative Council. Friends, here local representation means not Indians. Local representation means in the center, we have the Governor. For the Governor, we have Executive Council and the Legislative Council. And these Legislative Council have the representatives from the state governments. That means the Britishers who are running the state governments, or the British officials who are running the state governments. So they can be represented in this Legislative Council. So here not Indians, it is the local representation, means the representation from the states, that is basically from your Bombay, Madras, and so those provinces. And then evolution of constitution proceeds. We have Government of India Act 1858, that is after Sepoy Mutiny. So we abolished the Board of Control and Court of Directors here. And so we established Secretary of State for India in UK, and there was a Council of India established to assist the Secretary of State for India. And then we have 1861. Here Indians were added to the Legislative Council. So this was the beginning of Indian representation in the Legislative Council. That is why some books say that this was the beginning of Indian legislature, because Indians got represented there. And some books say that 1853, because here the Legislative Council was born for the first time in 1853 Act. Then Government of India Act 1892, power to discuss the budget and ask questions. So that was added as an additional power to the Legislative Council, and the members of the Legislative Council were increased from 6 to 16. And then Government of India Act 1909 also increased the members of Legislative Council from 16 to 60. And then we have Indian representation in the Executive Council. That means first Indian minister or cabinet minister was added. So we can say the cabinet minister counterpart of British times. And here we have Satyendra Prasad Sinha, the first Indian member to the Governor's Executive Council. So this was asked in prelims once. We will remember this. And then we have communal representation. That means for Muslims, the separate electorate was given by the Parliamentary Reforms or the 1901 Act. And then direct election was introduced for the first time in India, and that is why 1909 Act so provides for the first time the adult franchise in India. And then comes the Montfort Reforms 1919. Under this we have diarchy at the provinces. Friends, not at the center, at the provinces. That means at the province, some subjects were reserved for the governor, and then some subjects were transferred to the state legislative councils. And then we have UPSC established in 1926. UPSC gets the power from 1919 Act, and it was established in 1926. And then we have bicameralism. That means at the center there was attempt to introduce Rajya Sabha for the first time. And then 1935 Government Act, so from which Constitution borrows most of the clauses. Here we have All India Federation, that is we have central, state and concurrent list established. And then we have provincial autonomy. That means the provinces were given more autonomy rather than the centralization earlier. Then we have diarchy at the center. What was diarchy at the provinces in the 1919 Act? Now the diarchy came to the center with the 1935 Act. And then we have Federal, Provincial and Joint Public Service Commission being established. And the Act also gave for the Federal Court, which was established in 1937. That is the Supreme Court's version of the then times. Then one more important question asked in UPSC is regarding the princely states. Which act provided for the princely states the options to join either India or Pakistan? So here I have provided with the graphic. So here Mountbatten Plan is the one which provided for the princely states to join India or Pakistan. So it is not your 1935 Act, nor your 1947 Act, nor your Cabinet Mission Plan. So remember this very, very carefully. And then coming to the next one, phone tapping. Friends, phone tapping directly violates the right to privacy, which is a fundamental right to life. Here we can remember Puttaswamy judgment also. And phone tapping can be done by both the central and state investigating agencies. Say for example, the state police can do that, and in the central level CBI, Enforcement Directorate, and many other forces or authorities can do that. And phone tapping is coming under the Indian Telegraph Act 1885. And here the section 5 clause 2 of the act provides that phone tapping can be done in case of public emergency, in case of public safety or sovereignty and integrity of the nation, or if there is harm to the friendly relations with the foreign states, and also preventing the incitement for violence or offense. So that means in case of exigencies, emergencies, we can do the phone tapping. Then come to next one. Friends, recently Kerala Assembly has passed a resolution to rename the state as Keralam. And here, what are the procedures for that? The procedure is very similar to that of creation of a state. Here we will see the renaming of the state is governed by Article 3 of the Indian Constitution. And here this article empowers Parliament to alter the name of the state by law. That means through simple law, that is simple majority. A bill may be introduced for the change of the name in the Parliament on the recommendation of the President. So here mark it as important. And then the bill is referred by the President to the legislature of the state for expressing their views. And now whether they say yes or no is immaterial, the bill passes further. And then in the Parliament, the bill is passed in each house by a simple majority. Then following President's assent, so then the first and fourth schedule shall be amended and the name of the state shall stand to be changed. So remember that the change in the name, the procedure is very similar to the formation of a new state. Then formation of states. Friends, earlier so many factual questions were not appearing, but recently because of this question, we had to discuss that. Here we had that Arunachal Pradesh, the capital of Arunachal Pradesh is being named after a fort, that is Eta Fort, Itanagar. Then Nagaland was formed after the 6th Constitutional Amendment Act. And then Tripura was initially in the Part C. So here we will discuss some of the facts, how to recall them. Friends, here the cabinet mission provided for the 3 parts of the states. Part A had the Hindu majority provinces, and then Part B had the northwest frontier province, that is the Pakistan currently, and then we have Bengal and Assam. Tripura being a part of Assam will obviously be in the Part C of the group, and then we had Part D, which also included Andaman and Nicobar. And here we have the 6th Constitutional Amendment Act, which provided for tribal autonomy, and for the sake of tribal autonomy of Nagaland people, a separate state of Nagaland was formed. Yes, and moving further, I have brought a mnemonics for the order or the chronology for which the states have been formed. First was Andhra Pradesh. We all know that Potti Sriramulu attained martyrdom while he was protesting. And then comes the chronology. Karna ke Mahagun, Pandavon ko harana nahi tav. That means Karnataka, Kerala, Maharashtra, Gujarat, Nagaland, Punjab, Haryana, Himachal. Karna ke Mahagun, Pandavon ko harana nahi tav. So remember this on these lines. And then मन में तृप्त होना सीखो, मन में तृप्त होना सीखो, मणिपुर, मेघालय, त्रिपुरा एंड सिक्किम. मजे अचल है सिर्फ गोवा में, मजे अचल है सिर्फ गोवा में. So that मजे for Mizoram, so Z for J. So our Indian slang of Z we can remember likewise. And then Jharkhand, Chhattisgarh, Uttarakhand made in the same year 2000. This we can remember, and Telangana the latest one. And we can also go for your Jammu Kashmir if the statehood is provided. Then we have the committees. Friends, SK Dar committee came up for the first time for state reorganization. So they outrightly rejected language as the basis. For them, administrative convenience was the main criteria for formation of the states. And then came JVP committee, that is Nehru and Vallabhbhai Patel and Pattabi Sitaramaya committee. So that committee also rejected the language as a criteria. And then came Fazal Ali committee. Fazal Ali committee said language can be the criteria, but there is no criteria for one language, one state option. That means, say for example in Karnataka, Kannada is being spoken, but there are also people who speak other languages. There are Mangaluru people who speak Tulu language. You might have seen Kantara. And then Kodava people speak Kodagu language. So that means there is no separate statehood for Mangalore or Kodagu people. It is that Karnataka has one language Kannada, and there is no one language, one state criteria. So now you understood what is one language, one state criteria. So that is why Fazal Ali committee was a balance, and we followed with the Fazal Ali committee. And then we have the citizenship. Friends, there are so many facts associated. We will take up the important ones. So here we have the fundamental rights which are enjoyable only by the citizens. That is Article 15, 16, 19, 29, 30. Remember this phrase, 15, 16, 19, 29, 30. And then we have citizenship on the basis of birth, descent, registration and naturalization. Friends, on the wake of Citizenship Amendment Act, which was taken up in 2019, the citizenship by naturalization becomes important. Here, for naturalization, the criteria fixed by the Citizenship Act is 11 years of lawful residence and 12 years of residence before the application. That means 11 plus 1, 12 years of residence they have kept as a criteria. And now this 11 years is reduced to 5 years. That means in case of the newly amended Citizenship Amendment Act, so now if a citizen from Pakistan, Afghanistan or Bangladesh, if they want to take citizenship by naturalization in India, so then rather than 11 years, they have to stay only for 5 years plus 1 year, 6 years for getting the citizenship by naturalization. So this amendment only will look into, other facts we need not worry about. And then fundamental rights. Friends, like how to study fundamental rights, DPSPs and fundamental duties. Just see the article numbers and see the crux what the article says. That is more than enough. Here we have right to equality. So this we know, equality before law. Then we have the equal protection of the law here. Then opportunity in public employment, abolition of untouchability. Friends, Article 17 is right to equality, not right against exploitation. There was one question asked in UPSC, be thorough with that. Abolition of titles is also right to equality. Then comes right to freedom. Under this we have Article 19, which has freedom of speech, expression, residence, etc. And then we have Article 20, so the right with respect to conviction of offences. And then we have the life and liberty. Then we have right to education, and then protection against arrest and detention. So your arrest, detention, preventive detention all comes under Article 22. Then comes right against exploitation. Here we have the human trafficking, and then we have the child labor. So only these two rights are under the right against exploitation. So remember that. And then we have the right to freedom of religion. Here we have Article 25, which is freedom to profess, practice and propagate religion. And then 26, freedom to manage religious affairs. And then 27, that is no payment of taxes for promotion of any particular religion. We can pay the fees but not the taxes. Then Article 28, that is religious instructions at some educational institutions. And then cultural and educational rights. Friends, here we have only religious and linguistic minorities, that is Article 29-30, that is protection of interest of minorities and also say protecting their educational institutions or administering their educational institutions. Then we have 32 constitutional remedies. So these are the crux. We will do the same for DPSP and fundamental duties in the future sessions. Then coming to next, here we have a simple question on what is a DPSP, what is a fundamental duty and fundamental rights. So going through the crux, we can solve this question very easily. And then we have important amendments. Friends, again we will go through the crux. First Constitutional Amendment Act introduced 9th schedule. So remember 1 with 9. And then the 7th Amendment Act abolished the part A, B, C, D of the states. So what was given through cabinet mission, that was abolished here. And then we have 24th Amendment Act, so which provided extreme power for the parliament to amend anything including fundamental rights. So this was later struck down by the Keshwanand Bharati case and the doctrine of basic structure, which you already know. Then 42nd Amendment Act. Friends, this is known as mini constitution. We all know that. Here secular socialist integrity, they were added to the preamble. And friends, so 42nd Amendment Act was done during Indira Gandhi times. So whatever egregious amendments which were made during the Indira Gandhi times, and then came the 44th Amendment, which reversed many of such egregious amendments. So if you learn that trend, it will be very much helpful for you to take guesses. It is not that you by heart everything. So 44th Amendment reversed many provisions of the 42nd Amendment and the earlier amendments. And then we have 52nd Amendment, which is famous for anti-defection law. Along with that, we should also remember 91st Amendment, which is a sequel for the anti-defection law again. And then we have 61st Amendment, which lowered the voting age for Lok Sabha and State Assembly from 21 to 18. And then we have 73rd, 74th, which every aspirant kid knows this. And then 86th Amendment Act. So this is right to education. And friends, then we have 97th Amendment, which is associated with the cooperative societies. That also is worth remembering. And then we have 101st Amendment Act related to Goods and Services Act. And then 102nd, which provided constitutional status to the National Commission for Backward Class. And then we have 103rd Amendment Act, which provided 10% reservation for EWS. And then we have the latest 106th Amendment Act, that is Nari Shakti Vandan. So here we can see some of the questions. Friends, here Nari Shakti Vandan question was asked. Here it says that provision will come into effect from the 18th Lok Sabha. 18th Lok Sabha is the current ongoing Lok Sabha. It means the amendment came in the verge of the last times of 17th Lok Sabha, and once the amendment came, it cannot be implemented from the very next 18th Lok Sabha. So actually the implementation comes from 19th Lok Sabha, and this 18th Lok Sabha came many times in the newspaper because of the elections. The election for 18th Lok Sabha was going on every day. So if you just eliminate this one, you will readily get the answer. So we should be aware of the issues. Just glancing of newspaper will help taking 2 marks in this question, because we only get 2 to 3 months of time after 106th constitutional amendment came, and we cannot implement within 2 to 3 months in the 18th Lok Sabha itself. And then coming to one more question, consider the following statements regarding the 44th Amendment Act of 1978. It restored the powers of Supreme Court to decide on the election disputes of the Prime Minister. Yes, so whatever restoration work, 44th only will do, because 42nd Amendment and the previous amendments were done during Indira Gandhi times, and 44th Amendment restored it. So learning the hints is more than enough here. Then Presidential Assent of States Bill. Friends, here the Tamil Nadu governor case was in news. Here we have Article 200, which provides powers for the governor regarding assenting of the bill. It provides power for granting the assent, and then withholding the assent, and then returning for reconsideration, and then we have reserving for president's consideration. And then we have Article 201, which provides power for the president, what he has to do in case the bill is reserved for him from the governor. So he can grant the assent or he can withhold the assent. And also that if the bill is not the money bill, so he can also direct the governor to send the bill back to the legislature for reconsideration. And now here it is to be remembered that if the legislature passes it again, so now the president is not obligated to say assent the bill. So the governor has the obligation to sign when the bill comes for the second time after reconsideration. But the president doesn't have any obligation to sign it when it comes after reconsideration. That is why several bills were pending, and now Supreme Court interfered and they set the timeline. So now what are the timelines? If the governor decides to withhold the assent or reserve the bill for president on the basis of advice of the Council of Ministers, then he should do it within 1 month. And then if the governor withholds assent contrary to the advice of the Council of Ministers, then they are required to return the bill with a message for the legislature within 3 months. So if he is returning the bill within 3 months, he has to do. And if governor chooses to reserve the bill for president on the contrary of the advice of Council of Ministers, so then he has 3 months again. So remember 1, 3 and 3. So if you remember these, like factual questions, you can always answer in prelims. Then presidential reference and the constitutional bench. Friends, the Tamil Nadu governor's case judgment was provided by Supreme Court under Article 142. And Article 142 says that Supreme Court can give any judgment in the wake of doing complete justice to any issue for that matter. And now President questioned the case with the Article 143, that is the advisory jurisdiction, wherein the Article 143 provides power for the President to seek advice for the Supreme Court regarding any question of law or public importance. And on these lines, President had posed some 14 questionnaires to the Supreme Court. And in those questionnaires, some articles become important for us. President questioned that there is an article called 361 which gives immunity for the governor regarding the legal proceedings. So now Supreme Court judgment has violated that immunity from the legal proceedings. And then Article 142. So can Supreme Court take up any constitutional matters under Article 142? Even if they take up, Article 145 says that regarding any questions related to the constitutional matters, Supreme Court has to set up a constitutional bench which consists of judges of minimum 5 in numbers. So now without the constitutional bench being set up, so how can the Tamil Nadu governor's case judgment be dealt with? And then one more article which was important was Article 131. This article provides that the Supreme Court has to deal with the disputes between center and the states. And this has to be done with a special petition under Article 131. And this Article 131 was not invoked during the Tamil Nadu case judgment. So these are some of the articles regarding the presidential questionnaire. It is enough that we remember these articles. We need not by heart the whole questionnaire as such. And then coming to the last, success comes before work only in the dictionary. So make sure that you work hard, work smartly, work happily rather than anything else. So all the very best from my side. Good luck, friends.